Good morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is April 24th, 2019. The time is 9:30. With us today are Commissioner Emily Lindley and Mary Smith for the General Counsel's Office. I'm John Neerman, and Ms. Smith, I'll ask you to call the first item.
The first item is consideration of motions to overturn the Executive Director's approval of the application by Medcare Environmental Solutions, Incorporated. First, we recommend that the Commission hear from the movants, followed by the applicant, the ED, and OPIC in that order. By letter dated April 12th, 2019, OGC provided the following oral argument time limits. Movants, 10 minutes collectively. Applicant, 10 minutes. ED, 5 minutes. And OPIC, 5 minutes. The movants may save some of their time for rebuttal as they bear the burden of proof. And that brings us to Mr. and Ms. Perez for the movements.
Good morning, and you can split your time however you like.
Thank you. I'll try to keep it to 5 minutes.
Thank you. And start with identifying yourself for the
Yes,
record.
Sir. Yes, sir. Good morning, Chairman Neerman, Commissioner Lindley, General Counsel, Public Interest Counsel, and my name is Vince Pettis. I serve as County Commissioner for Precinct 3, which is the area that the applicant is seeking to locate in this case. I'm accompanied by my wife, who's also the city councilwoman for District 6, the municipal district of where this facility is seeking to locate. We thank you for the opportunity to speak before you today. We respectfully request the Commission to grant the motions to overturn or to remand the application for further review and assessment. Following the Executive Director's approval for registration in January, my office began a fresh review of all the documentation to determine if filing a motion to overturn was appropriate. Upon reviewing correspondence between the applicant and the city's Planning and Zoning Department, we believe the applicant omitted, misrepresented, or provided incorrect information to obtain the least restrictive zoning determination, an M1 designation, which does not accurately or fully reflect the scope of operations this facility will undertake. After city planning and zoning staff determined that Medcare's proposed operations are most similar to the heavy processing facility use, a more restrictive use, as outlined in city code, the applicant contended in correspondence that their operations were most similar to a recycling collection facility, even suggesting that waste byproduct can be converted into electricity, even though no facility in any of the states the applicant seeks to operate is approved for such use, nor was it mentioned in his application. The applicant also did not disclose to zoning staff his intention to store medical waste in outdoor containers for periods exceeding 72 hours, and did not disclose intentions to use compactors outside the processing facility. These operations do not conform to light intensity activities, which are typically similar to light manufacturing, assembling, distribution, and warehousing. For these and other reasons, the Planning and Zoning Department informed the applicant that vital information was not provided to the City of El Paso, and they issued a revised zoning determination on April 3rd. As it stands today, the proposed facility does not conform to the permitted uses within the zone it is located, and the applicant does not have any of the necessary approvals to operate at the proposed site. From our understanding, under Chapter 326.71, subsection 4 of Title 30, if the facility requires approval as a non-conforming use or a special permit from the local government having jurisdiction, a copy of such approval shall be submitted. We believe the application should, at minimum, be remanded for further review of this matter. And I believe the first slide, I don't know if there is a presentation, the first slide was the letter from the city's Planning and Zoning Department, which issued the revised determination where they do not conform to that particular zone. There are other issues with the proposed facility that are not mentioned in Medcare's application nor in the Executive Director's approval. Under Chapter 326.71, subsection H3 of Title 30 of the Administrative Code, no solid waste unloading, storage, or processing operation shall occur within any easement, buffer zone, or right-of-way that cross the facility. Processing equipment and storage areas shall maintain a minimum separating distance of 25 feet between the facility boundary and processing equipment, loading, unloading, and storage areas. I think the next slide. The next slide demonstrates, as you can see, this was the diagram that was provided by the applicant in its application for registration. As you can see from the applicant's survey provided in the application to TCEQ, there is no 25-foot buffer, and the processing, storage, and handling facility is within 2.3 feet of the property boundary there on the eastern side. And a small portion of the existing building is within an easement. The code also states that the buffer zone shall not be narrower than that necessary to provide for safe passage for firefighting and other emergency vehicles. There does not appear to be a 25-foot buffer on the other side of the facility to the west. According to the attached survey, the width of the property is 102.5 feet, while the width of the building where the processing and storing operations will take place is 80 feet, leaving only a little over 20 feet separating the building from the property line to the west. And as you can see from the survey, there is only 10 feet separating the property line and the building on the northern boundary. While the executive director may consider alternatives to the buffer zone requirements, it does not appear that any alternatives were provided. Furthermore, allowing any potential alternatives or variances would be ill-advised, as the building itself is only 80 feet from the property line of existing residential areas. Next slide will demonstrate that. The only way for emergency vehicles to access the building is through the front of the property, and it does not appear to provide for safe passage as stated in the code.
That's 5 minutes.
Okay. Next slide, please. Of the 14 active medical waste facilities, we could find no other circumstance where we have such close proximity to residential areas as a proposed facility. Only one facility that may be a runner-up to this site is in Pasadena, in Harris County. However, that is a non-zoned municipality with no authority to regulate land use. Every other medical waste facility in Texas is located in sparsely populated areas within large industrial parks or integrated as ancillary facilities within large hospital districts. And then I will yield time to Councilwoman Ordaz.
Thank you. If you want to go to the next slide, please.
And would you
Yes.
state your name for the
Yes, sir.
record?
And the next slide. Good morning, Chairman Neerman and Commissioner Lindley, Director Baker, General Counsel, and Public Interest Counsel. For the record, my name is Claudia Daz Perez, City Councilwoman for the City of El Paso. First, I want to thank you for your service and for allowing us the opportunity to address the Commission. My comments today are largely going to be focused on the issues of land use compatibility, referenced under Chapter 30 of the Texas Administrative Code. Within a 1 mile radius, if you want to go to the next slide, please. Within a 1 mile radius of the proposed site, there are 7 schools, 5 churches, 5 parks, and within 80 feet from the property lines of existing and established residential neighborhoods. Next slide, please. The applicant states in his application that the proposed land use is compatible with current growth trends in the surrounding area. I can tell you there is no such evidence to support this claim. As a matter of fact, an examination of surrounding development shows that growth within a 2 mile radius of the facility shows growth of multifamily residential complexes and low-intensity neighborhood commercial development. Notably, you can see in this chart, close to half a mile away, there is currently a 360-unit apartment complex under development, a 216 apartment complex that was built in 2018, just a little over a mile away, and 96-unit apartment complex built in 2016 within a 1 mile radius. Next slide. As City Councilwoman for this area, just in my time in office, we have invested over close to $4 million to these surrounding parks and libraries to increase the quality of life for families living in established and stable neighborhoods. We wouldn't be making these types of monetary investments for residents living in this area if growth trends were moving towards industrial uses. There is just no such evidence to support the applicant's claim. Next slide, please. The closest industrial parks that allow for heavy industrial uses are 5.5 miles away, and most notably, Inglewood Industrial Park is located at the fringes of El Paso city limits. Next slide. On April 3rd, the City of El Paso's Planning and Inspections Department, upon further review, determined that the proposed facility is not conducive to the surrounding area and not permitted within an M1 light industrial zoning district. under Chapter 326.71, A325, under Title 30 of the Texas Administrative Code, the ED has the ability to evaluate the impact of the facility on the surrounding area. And for these reasons, we respectfully request the Commission consider granting motions to overturn or remand the application for further review. Thank you very much.
Thank you. Commissioner Lindley, any question for the movements?
Just one or two quick questions, and if you guys aren't the best to answer, that's totally fine. First, thanks for making the trip to Austin,
Oh, no.
especially in this weather.
Thanks for having us.
What other kinds of industry are in the area right now?
So in the site where the applicant is seeking to locate, it is all M1, which is all the least restrictive light industrial. So it's all
Warehouse
M1.
type?
Warehousing, trucking facilities,
Okay.
things of that nature.
Okay. And so, I guess initially when this site was approved for these zoning requirements, what was y'all's understanding of what the operation was at that time?
When we received notice actually from one of our neighbors, there were some issues with notification. We just understood that it was going to be a medical waste facility. We had to learn what that was. There isn't one currently in the city of El Paso. And so through the process, we were able to learn about the operations of that site. But it's clear that it doesn't really conform to the current land use that's currently there for M1.
Okay. Thank you.
Thank you.
Thank you.
I understand Mr. Rodriguez is here for the applicant. Good morning.
Good morning, Mr. Chairman, Commissioner Lindley, General Counsel.
Would you make sure that you speak into the mic or maybe the light? Make sure the light's turned on for starters.
I think I may have turned it off. How's that?
We got it.
Thank you. My name is Art Rodriguez. I'm with the law firm of Russell Rodriguez Hyde Bullock, and we represent Medcare Environmental Solutions. In this case, I kind of want to start by saying that the responses to the motions to overturn that were filed by the executive director, we agree with the statements and the arguments that were made therein. We also agree with the statements and the arguments made by the Office of Public Interest Counsel, with one exception, and the exception being the land use compatibility. That seems to be the only issue that remains in place here today, and those are the issues that we want to address with respect to the motions to overturn. Nord Sorensen, I'm joined here today. He's the Chief Executive Officer for Medcare Solutions. He and his partners have been in solid waste and in medical waste for well over 50 years. They understand what it is to be in a community. They understand what it is to do to comply with zoning. This is nothing new for them. When in 2017, when they sought to find a place for their medical waste processing facility, they actually leased property on a long-term lease, but it wasn't from the very beginning that they have it. There actually were some trigger points there. The very first trigger point in order to get to the long-term lease was to be able to comply with the zoning requirements of the city. At that point, after they got it in September of 2017, they went to the city, had multiple meetings, multiple emails with the city, to tell them what the medical waste facility was. There is no right for a medical waste facility in the City of El Paso zoning ordinance. It just doesn't exist. They never addressed it in their zoning ordinance. Mr. Sorensen went to the city, got 2 land use determination letters from them, both in October and November of 2017. At that point, when that trigger occurred, is when they filed the application with the TCEQ. At that point, understanding that the land use, that the use was compatible with the zoning as determined by the city of El Paso, they came to the city. They had public meetings. At that point, city of El Paso and the county were notified of the application, just like all the other landowners were. At no time in that during that period of time did the city of El Paso, the county of El Paso, the Office of Public Interest Counsel, or any other parties provide any kind of documentation or any kind of evidence that this use was incompatible with what the city of El Paso had already determined. When we received when Medicare received their registration, there was also response to comments on that. Now, it's interesting to note that with the county commissioner, they didn't begin their process of evaluation of this until after the registration had already been filed. It's interesting also that the Public Interest Council didn't make their land use determination without providing any kind of evidence as to what their qualifications are to make any land use determinations until the response to the motions to overturn were filed. At this point, the Medicare should be has expended a significant amount of money, close to $200,000, in preparation of the application, in plans. They've begun actually talking with medical facilities in El Paso to accept the waste because it's a needed service for the city of El Paso. That there's not another facility like that we're aware of in the area. None of the historical sites are within a quarter mile of this facility. You have to start looking at the bigger map a mile away in order to start seeing historical sites, churches, etc. Well, I would submit to you there's probably not an area in the city of El Paso that doesn't have those types of facilities within a mile of anything in the city. They're just very common, and what Medicare did when they filed the application is they looked for a site that was convenient to not only the sources of medical waste, but also fit into a industrial zone. They did that as the maps that you've seen. They've got industrial zones on both sides of the property. They've got industrial zones across the street. There's actually a railroad spur that goes right in front of the property for the purpose of the medical. For the industrial facilities that are there. There's an 80-foot buffer. There's an 80-foot drainage ditch. It's more than just land. It's an 80-foot drainage ditch from the backside of the Medicare's facility to the nearest neighborhood. It's very difficult to determine how they would be in any manner impacted by a medical waste facility that essentially inside the operations all they do is steam the materials that they gather. The materials are then steamed and cleaned, and the condensate from the steaming process is then input into the sewer system for the city. The manner in which we're having to defend land use compatibility in this case, which wasn't brought up by the Office of Public Interest Counsel until the motion to overturn, the response to a motion to overturn was filed, giving us really no meaningful manner in which to address the concerns, is problematic in that the registration and the comment period had long been over by that. Months and months had gone by. To our knowledge, City of El Paso, the County of El Paso, neither have passed any kind of resolutions opposing our facility. In fact, when the facility was first proposed, Medicare went to the Council of Governments, both with the City of El Paso and the County of El Paso, as participants in that organization to determine if this facility met with their solid waste management plan, and got positive approvals from them at that point. That was in early 2018. So 2018, 18 months later, we should be, quite frankly, we should be able to rely on the representations made by the governments. We should be able to rely on the land use determination, two land use determinations that were made, with many emails going back and forth between Mr. Sorensen, and the city of El Paso, they had notice of this application. Not only at the time that we met with them, but at the time that they received notice of the application in, I believe it was March of 2018. To fast forward now until the registration and bring in, essentially, registration was issued, response to comments were issued at the same time, January earlier this year. The record's essentially closed in this case. To now be able to not be able to rely on government, what the governments have told us all throughout this process is problematic, not just for my client, but for all entities in the state. We should be able to go to our government, tell them what's going on. Quite frankly, if y'all issue if you deny the motions to overturn at this point, Medicare still understands that they've got other regulatory permits that they need to get. They understand they're going to have to deal with the city of El Paso. They understand that they are going to have to defend their rights to that property, and are willing and ready and prepared to do it. Just the manner, but Mr. Sorensen, Medicare, Environmental should be able to rely on all the time that the cities had, all the time that the counties had, and to be able to operate their facility and get the registration. At this point, we request that you deny the motions to overturn and allow the registration to stand. I'm available for any questions you may have.
Thank you. Commissioner Lindley, any questions for Mr. Rodriguez?
Excuse me. Just one. Probably just one. Looking at the application and the narrative that was provided in the application, it states that there were 9 lots within a 500-foot radius rather than the 1 mile requirement by rule. So just kind of want to hear the explanation on why you didn't include the 1 mile radius information in that narrative. And if that's kind of an in the weeds question. So what I'm referencing is, in 30 TAC 326.71, it's stated in A5C, and what it says is the owner or operator shall provide the approximate number of residences and commercial establishments within 1 mile of the proposed facility, including the distances and directions to the nearest residences and commercial establishments. And there's some other stuff, but I believe that you provided the information for that.
Yeah, and my apologies, Commissioner. I didn't prepare the application. It was done by Medicare's engineer, so I can't speak to the fact that as to why it wasn't included in the application from the very beginning. But I can tell you that the application did go through some NOD processes with the commission, and hopefully those were addressed at a later date, maybe not with the initial application.
Thank you. That's my only question.
Thank you, Mr. Rodriguez.
Yes, thank you.
Executive Director.
Good morning. Good morning, Chairman Neerman, Commissioner Lindley, General Counsel and Public Interest Counsel. I am Kathy Humphreys of the Environmental Law Division. With me today is Chance Gooden of the Waste Permits Division. The Executive Director considered all of the issues raised in the MTOs and maintains his position that at the time staff reviewed the Medicare application, it met all applicable statutory and regulatory requirements, and the issuance of the registration was appropriate. The Executive Director's response addresses each issue raised in the MTOs. In the interest of time, I'm going to focus my discussion on land use issues. The Executive Director must consider the impact of the proposed facility on the surrounding community. To assist the Executive Director's review, applicants must provide a land use map showing the facility boundary and any existing zoning on or surrounding the property and actual uses of the property within 1 mile of the property. Available public zoning maps for the facility within 1 mile of the facility. Information about the character of the surrounding land uses within 1 mile of the proposed facility. Information about growth trends within 5 miles of the facility with directions of major development. And information on the proximity of the facility to residences, business establishments, and other uses within 1 mile, such as schools, churches, cemeteries, historic structures and sites, archaeologically significant sites, and sites having exceptional aesthetic quality. Of particular importance to the issues raised in the MTOs, the application included a zoning map published by the City of El Paso and a letter from the City of El Paso Planning and Inspections Department dated November 8th, 2017. According to the zoning letter, the property where the Medcare facility would be located is zoned light industrial. Additionally, based on the information submitted by Medcare regarding its operations, the Planning and Inspections Department determined that the Medcare facility would be considered light industrial for zoning purposes. Furthermore, the application included a map noting the existing types of development within 1 mile of the facility. According to the map and the application, the existing development includes industrial, commercial, and single-family residence. Within a 500-foot radius of the site, there are 3 blocks zoned as commercial or light industrial and 9 blocks zoned as residential. Some of the commercial light industrial lots are developed. The lots zoned as residential have homes. Within a 1 mile boundary from the proposed site, there are several parks, schools, and licensed daycare facilities, churches, and hospitals. During the executive director's review of the Medcare application, staff considered all the application in the application, including the information regarding land use, and determined the facility would conform to the requirements for issuance of the registration. Staff's review was consistent with the review process for similar medical waste applications. Subsequently, on April 8th, Commissioner Perez and Mayor Pro Tem Ordez Perez provided additional information regarding the revised zoning determination from the City of El Paso's Planning and Inspections Department. The revised determination indicated that the Medcare facility does not comply with the zoning requirements at its proposed location. However, this is new information that was provided after staff's review of the application. Therefore, in conclusion, the executive director recommends denying the MTOs because Medcare met all applicable statutory and regulatory requirements at the time the application was submitted. Additionally, it should be noted that Medcare cannot operate the facility until it has obtained all required permits and authorizations, and we're available for any questions.
Thank you. Commissioner Lindley, any questions for staff?
I guess I'd kind of ask the same question I asked the applicant. You know, how did the ED get to the determination that meets the requirements of for land use compatibility, and how the applicant checked the requirements of what I referenced earlier, which is 326.71A5C. Is that close enough?
Yeah.
So, part of our remarks was how we gather the information. So, part of that process is going and ask the applicant to gather what is around that facility, the surrounding land use, any kind of zoning, any archaeological sites, historical facilities, churches, schools, and we gather that information as a part of the review process. There are some things that we can look at towards the rule to evaluate those things, and then there's other things that are before our commissioners to decide if it is appropriate. And in this case, with the city providing a letter through that review process saying that it met that code for light industrial, the ED relied on that at that point. It wasn't brought to our attention until the motion to overturn for us to understand that there may be a difference of a determination here regarding what this facility is deemed as for light industrial.
Do you have questions?
I don't.
I guess another question I have. So, from what I gather, but if this isn't right, please correct. So, the applicant came in, they provided some information. The narrative says that there are 9 lots within the 500-foot radius, and so it seems that 9 lots. I guess I need to know how 9 lots checks the box as far as providing the requirement for, that the applicant shall provide the approximate number of residences and commercial establishments within 1 mile. And let me also say this, as far as the city's revised zoning determination, I recognize the ED has to go off of what you have in front of you at the time that you get the application. And I completely recognize that if we were to overturn a permit or a registration at any time, or every time a local government, rezoned an area that was different, that rezoned an application that was affected by a rezoned, hopefully that makes sense,
Yeah,
that would,
I agree. I get what you're getting,
that
what you're getting
would
at.
be, that'd be very troublesome. Permitting would come to a screeching halt. That would provide a level of uncertainty. I don't want to go there.
And let me, if I might just restate that, I think it's inappropriate for us to look at what a local governmental entity might say post hoc.
I completely agree. So keeping that in mind, kind of my question is, how did the ED determine that, that the operator shall, make every effort to show the location of residences, excuse me, and that the operator shall provide the approximate number of residences and commercial establishments? Because that's kind of the piece where I just need some clarification. I'm not necessarily hung up on it, but I need some clarification on
Sure.
how does the 9 lots answer that shall,
Okay.
if that makes sense.
Of course. So as a part of the notice requirements that the ED has to do, there was a discrepancy, I guess not really discrepancy, but administrative process that goes in notifying the individuals that are within 1 mile of the facility. When we're printing the labels for the number of folks that are on the list, it was inadvertently that there was duplicate labels within that mailing label list. In addition, some double-sided issues. And when the initial notice went out, several of those individuals that were noted, maybe of those 9 lots, didn't get a notice. That was brought to the agency's attention. We then did a revised notice to ensure that everyone that was adjacent and within that 1 mile radius of the facility did indeed get a proper notice that this facility was going in to their area. In regards to the 9 lots being within the 500 feet, we relied on the zoning requirements that the city gave the applicant that was published. And those 9 lots are just so happen to be on that line of residential versus in light industrial.
Okay, I think I'm good for now. Thank you.
Thank you.
OPIC.
Good morning. I'm Vic McWhorter. Dominique McLagan-Brown and I have prepared OPIC's response to the motions to overturn. OPIC is respectfully recommending overturning the issuance of this registration based on concerns about the facility's compatibility with the surrounding area. With respect to the other issues raised by the motions, including sufficiency of notice, operational requirements, and water quality concerns, we agree with the ED that the application satisfies applicable regulatory requirements. Our recommendation to overturn the registration is based solely on land use compatibility. The Commission has authority to evaluate and consider the impact of a proposed facility on the surrounding area under the Commission's Chapter 326 rules. Specifically, Rule 326.71 requires an application for this type of registration to state the approximate number of certain uses within 1 mile of a facility to assist the Commission in its evaluation of land use compatibility. From the contents of this application, as well as from the voluminous concerns expressed by local El Paso area opponents of the facility, we know that within a 1 mile radius of this site, we have populated residential neighborhoods with hundreds of concerned citizens, and more specifically, as you've already noted, 9 residences within 500 feet of the site. From information from school district officials that have been submitted, it's claimed there are 7 schools with student populations of approximately 2,500 school children in the area, numerous churches, parks, and recreational areas, and we have several sites of unique historic, religious, and cultural significance. But importantly, Rule 326.71 does more than ask for a recitation of numbers of different types of land uses. It asks for an evaluation and an assessment of land use compatibility. Although the application recited numbers about the types of certain neighboring land uses and sites, it really provided no meaningful analysis. We acknowledge the Chapter 326 rules provide no bright line test, no formula for how to weigh these factors and make land use determinations. And I'm certainly not an expert, as the applicant pointed out, but it seems that these assessments must be done on a case-by-case basis, considering the unique attributes and characteristics of a particular area. And we certainly acknowledge reasonable minds can differ about land use compatibility when looking at the same set of factors. In this particular case, with these particular facts, when we looked at the motions and were asked to prepare our response to them, we considered that we have several neighborhood associations, school district officials, and elected officials who seem to be the people most familiar with local land use, expressing strong opinions that the site is not consistent with the character of surrounding neighborhoods. OPIC views their concerns as reasonable, given the known facts that we've all talked about and seen in the application materials about land uses near the site, and the application materials have not convinced us otherwise. OPIC finds the application's land use compatibility representations to be conclusory and unaccompanied by any meaningful evaluation of land use or factors associated with the public interest as required by Rule 326.71A5. So for those reasons, considering the unique attributes and characteristics of the surrounding area and the lack of what we found to be any meaningful evaluation or assessment under Rule 326.71, that's the reason we respectfully recommend overturning the registration.
Thank you. Commissioner Lindley, any questions?
No questions, thanks.
Commissioner Lindley, the answer to your specific question earlier was in response to notice of deficiency number 3. It's on page 13 of the response to that notice of deficiency number 3, where it says there are 7 schools, 5 churches within 1 mile of the Medicare facility, 5 recreational areas, and no cemeteries or lake within 1 mile.
Thank you. Mr. and Ms. Perez, you have 2 minutes of rebuttal time.
Thank you, Mr. Chairman. Just to address a couple of points as quickly as I can. Regarding the initial zoning determination, again, keep in mind that the City of El Paso does not have a definition for a medical waste facility. When Medicare first applied for this back in October, the City of El Paso originally denied their operations because they said that based on the shredding and a lot of the other operations that are going on, it is most consistent with a heavy processing facility, which does not qualify for the M1. Claudia as a city's official cannot get involved in zoning determinations. You know, we have been to the public meetings, we've been involved with this process for a while. If there was an opportunity to change the zoning, and if it was that simple, it would have happened earlier. What happened in this case was not a rezone. There was information that the City of El Paso felt that the applicant did not disclose regarding its operations, and it made a revised determination that it does not meet the M1 zoning determination because it presented itself as a recycling facility. And so they said, and here I have the correspondence here where they're telling the city that their operations are much cleaner than a recycling facility, that even part of the waste will go to be recycled, but that's not the case. It does not meet the definition for recyclable material. And so I just want to make that clear that this wasn't a rezone. This is where the city felt that there was vital information that was not provided to them. When it comes to notice that was provided, you know, it says that the county and all was notified. as is often the case with these applications, notice is sent to the county judge. County judge, an independently elected official, has no obligation to share that. Yes, notice was sent to him. Notice was also sent to the mayor. That did not trickle down to each one of our respective offices. And again, it's hopefully something that can be changed at some point, that more representatives are notified, but simply notifying the county judge or simply notifying the mayor is not sufficient, because in this case, it did not trickle down to the representatives who represent that area. It was also mentioned that the county and the city didn't file resolutions. We felt that it wasn't material or wouldn't make a difference. I mean, we can go to our respective bodies. I have Commissioners Court on Monday, and she has City Council Tuesday, and get a resolution, but we just felt it wouldn't have made a difference.
That's
in
time.
this proceeding.
I'll ask you to quickly wrap up.
Sure. And is there anything else you want?
Sure, just quickly. Based on the public hearing that was held in October, I did raise concerns about how there are discrepancies from what was submitted to the state of Texas and what was submitted to the city. Under further review, that is when we discovered the original letter where the city determined its original determination that this is a large processing facility and it would not be permitted under M1. And when you had asked the question about what is surrounding that area, the highest level of use is M1, which in this case, this would not be permitted under that use because it's largely residential and commercial development. So those are quickly just some comments, and if y'all have any questions, please let us know.
Thank you. Commissioner Lindley, any questions?
I don't think so. Thank you. I do have one more question. This is probably best for the executive director, but there might be others that need to jump up. I feel like there were different numbers rattle off on easement and buffer zones, and I'm a little unclear as to what, and I guess I need y'all to answer what we got in the application, what you verified, and just kind of clear that up for me, because I've heard different numbers here today.
Of course. Yes, there is a 25 minimum buffer. The rule does allow for them to request an alternative. We do have sites in Texas that do request a 0 buffer. In this case, they did not. The buffer, in the application, page 24 of the application, they state that all medical waste handling, storage, and processing will occur within that 25-foot buffer, or outside the 25-foot buffer.
Okay, thanks.
You're welcome.
Any other questions?
You want to start, or shall I?
I'd love for you to.
Okay. First off, let me say I appreciate the need for this type of facility in El Paso, and I appreciate Medcare's significant investment in this permit. And I understand that there are differences of opinion about what exactly transpired in the conversation around zoning requirements. I think I can set that all aside. The commission, in my view, has an independent obligation to look at land use compatibility. And this application demonstrates that there's a potential for equipment failure. There's a potential for accidental spills of medical waste. There's a potential for unauthorized air emissions and specifically odors. And that potential, in my view, Commissioner Lindley, is incompatible with the residential neighborhood that's adjacent to this facility. By my lights, it appeared to me that there are residential properties within 150 feet of the medical waste processing building. This morning, I think I saw the 80-foot dimension called out. There are, by my count, looking at the exhibits, at least 17 properties, residential properties, that are within 500 feet of the site. I know the number 9 has been cited here. I don't know that that difference really amounts to anything in my analysis. There are a number of residential properties nearby. There are over 100 homes within a quarter mile of this facility. And so, Commissioner, I think it's appropriate that we overturn the issuance of this registration and deny the application. And I'd be interested in hearing your thoughts on it.
Oh, this one's really tough. It's technically challenging. It's, you know, the location of it is challenging. I probably need about a 5 minute, maybe not even 5 minutes, a break, a minute or two break to gather some thoughts,
Sure.
if that's okay.
Sure.
I'll come right back.
Yep.
Thanks. Thanks, appreciate that.
Sure.
Okay, I just want to dive a little into one topic I kind of brought up already again, just for understanding purposes. So the issue of a buffer and easement. So the requirement is there has to be a 25-foot buffer. Explain, I mean, is that the processing? Is that the site? And 25 feet from what? And why is there kind of a discrepancy? And if we need to hear from others, I think that's allowed, if that's, I think the county commissioner referenced a different number, so I'll let the ED go first.
Sure. Before the medical waste rules 326 existed, they were in the 330 rules. And so part of a legislative session, we carved those rules out of there. So the buffer was 50 foot. Through the stakeholder process, we decided a 25-foot buffer, but stakeholders then commented, we have a lot of these processing facilities in shopping centers, and we want the ability to, and they're in a strip mall, so we want the ability to have a zero buffer, because if they're in buildings, inside of a building, those shopping centers inevitably have a fire lane behind the shopping center, and people can get around. And the medical waste processing is from a stakeholder's perspective, medical waste processing is more viewed like packaging type of process. So all the materials enclosed in bags that are also put into enclosed storage containers, and they're refrigerated and transported back and forth. So through that process, we allowed them to request an alternative buffer if they were in some type of situation where the facility was in a shopping center area. In this case, they didn't need to request one, seeing they're in light industrial, and the building itself was significantly away from the property boundary.
What's significantly away?
Well,
do we know?
80, I think it's 80 feet.
The end of the building to the property line, or the end of the processing?
I think that's from the front. I'm not sure what it
Okay.
is from the back, but
No, the 80 foot, I think, is from the proposed site's property line to the residential area across the railroad tracks and across the canal. I think the distance between the processing building and the back fence is about 10 feet. And from the processing building to the front of the lot, where it fronts the, I think it's Billy the Kid Street,
You're right, yeah.
is a great distance.
Yes.
I'm not recalling what it is. It may be over 100 feet,
yeah, when we
180 feet, something like that.
Like when we went by the site, we didn't go in, but at the gate, the building is in the back of the property. Regardless, all the handling of that medical waste is going to be occurring outside of that 25-foot buffer. And that's
Closer to the Billy the Kid Street? Is that fair to say, or do we know? And maybe that's a question for, well, do you know I'm sorry, I don't want to
I mean,
cut you off.
yes, I mean, I don't know the exact distance from the Billy the Kid Street, but what the 25-foot minimum buffer is from the back of that property. That's the minimum distance from the back of that property and to within that building to where the medical waste handling and storage would occur.
And I think
That's
it'd
the
be,
20 So, I'm sorry, go ahead.
sorry to cut you off.
Yeah.
Just to finish the thought, I think as soon as the ED is finished with his description, we'll have Mr. Rodriguez and then Mr.
Okay.
Perez respond to the same question. So I'll
Okay.
let you finish your answer, and
Yeah.
I'm sorry to interrupt you.
So there is an area within that building that medical waste processing would not be able to occur because that is also incurring that part of that 25 from within that building all the way to the property line.
Okay,
Does that
Thanks.
make sense?
yes.
Mr. Rodriguez.
Yes, sir. Yes, I'm Norton Sorensen, I'm the CEO.
Good morning, sir.
And good morning.
Would you turn on make sure that mic is on?
All right. Now, can you hear me now?
I'm not sure I'm hearing you. We got it.
Thanks,
All right.
Megan.
I'm Nord Sorensen. I'm the president of Medcare. And addressing these buffer zones, you're right, the building sits on the property line, on the east property line. And what we did with the TCEQ, and we worked with them, we moved all operations within the building in 25 foot. So they're within the building, that buffer zone is all maintained within that building. And there's nothing to be done in that area. That's all kept clear and the like. And the same thing on the west side of the building. Yes, there's that alleyway, but that provides for 25 foot also on the west side. On the south side, there's a dock out back, and that's all kept clear. So all that medical waste and everything is done on the inside of the building. Now, there's a compactor container that's outside that's totally enclosed. And it's erroneous when people say there's going to be waste outside or the like. There's not. Anything that's kept outside will be in refrigerated trailers that are delivered into the facility. So it's a very, very, very clean facility, like Mr. Gooden has said. And it can be in a lot of facilities are in very, very tight areas where there are neighborhoods in those areas. So anyway,
Thank you, sir.
thank you.
Any other questions?
Thank you.
No.
No. Mr. Paris?
Commissioner Lindley, if I may approach and demonstrate, this is their actual application that actually has the diagram of the building. It is impossible for them to relocate their operations. There's only 2.3 feet separating the building from the right property line. If you look
And
at
I think we had a slide up earlier. Can we bring that up again?
Yes, and if I may show you.
That's fine. But I think what I'm understanding is that it's a building, and that building, it sounds like what you're saying, the actual physical building backs up, and that's a 3-foot area, but all the processing is inside that building, and at the back of that building where we get to the property line, there's a 25-foot buffer.
And see, so the whole width, it is a very narrow property. It's a long property. The facility itself is in the back corner of the property. So you have the 2.3, and these diagrams will clearly demonstrate. It's 2.3 feet on the eastern side, and again, the whole width of the property is 102 feet. The building itself is 80 feet. So that's why you only have 2.3 feet on the right side, and then you have, I believe, 20 feet on the left side, and I think that survey will demonstrate, and then only 10 feet on the northern boundary. But you can see there's two diagrams there. One of them was this one that's posted up that we provided earlier. But I mean, as you can see, the building is right on. So it is impossible for them to relocate the operations. And you can see from the diagram of the building that's different from this. It shows where each of the operations are. It shows where the medical processing is taking place. It also shows that there's also storage taking place. And then it also shows the flow-through washer, which is also diagrammed. That is not more than 25 feet away from the property line.
AD, do you have? Yeah.
Okay, so since the building does sit 2 to 3 feet from the property line, that's why we had them move all the waste processing, storage, and equipment within that building. So there's parts of that building that there can't have any medical waste handling to accommodate the 25-foot buffer from the property line.
So this was the original application, so this is changed what I would be looking at more than likely?
No.
I don't, yeah, we had them update.
Okay.
It's not in the application. It was in a response to an NOD.
I don't have that actual page before me,
That's-
but I
yeah.
can pull it.
No, I'm good, thank you.
And I was surprised that this was not addressed in the executive director's approval, where it gives special considerations. But the only way, unless there is a magic sort of middle area of that facility, it's a very odd, narrow property. But I don't know why this wasn't. Again, there is a variance process that can be applied, but no variance was applied by the applicant, nor did the executive director pursue a variance process.
It sounds like we found that information out through an NOD. Or, no.
Correct. The point we're trying to make is the buffer can be within the building. It doesn't have to be the building itself. So from the property line through the
Right.
building wall to on the building floor, then there's a 25-foot buffer. The equipment's within that.
Got it.
And again, but that diagram demonstrates that they would significantly have to alter their operations from what is presented in the application to be within the 25 feet because the property itself is so narrow. I just don't understand how they can do that.
Okay,
Thank you, Mr. Perez.
yeah. Yeah. Well, I thought that would clear things up. So, kind of where I am, like I said, this is really a really difficult one. I've gone back and forth for a number of days now on what to do on this. So, I'm not, it's hard for me to support overturning because of the discussion of a potential issue. I'm not fully comfortable because it's a registration with overturning it because I don't want to set any kind of precedence. And I think you'd probably say this is a case by case. This is just in this case example, but I don't ever want to set any kind of precedence where we are overturning or not allowing a company to get a registration or a permit from us because of a potential environmental issue. You know, if the company abides by their permit or a registration in this case, if something were to go wrong, that would be addressed in enforcement. And so I'm a little uncomfortable with overturning or not allowing them to have their registration because of the potential. Now, the one thing I did get hung up in a little is more on the fact that the applicant, which, you know, I know that the original applicant, the engineering company that filed the application isn't here, but that, you know, in our rules, we require that the owner operator shall provide the approximate number of residences and commercial establishments within 1 mile. Looks like to me what happened is they supplied some information. I think it could, you might be able to mischaracterize it, or you might be able to say that it mischaracterized that piece of property and how close it was to residences, because there's a lot of residences, there are clearly over 9 lots. But through NODs, the applicant did end up supplying a full landowner list with their addresses. And so we have all the information that's technically, I think, required in order to meet our requirements for a registration. So that's where I've really been going back and forth. I think, you know, and
if I could just interject, I think.
Yeah, I'm sorry.
Yeah, I think having the information to make the evaluation is different than conducting the evaluation. And I understand why staff did what they did. They looked at sort of what was the state of play with the local zoning conversation, and that makes sense to me.
Yeah.
Yeah. But
That's a big factor, because when the application came in, which is what we have to go off, the local zoning was what it was. And, you know, unfortunately, that's what the ED has to go off of. And so I'm not sure that's just not really, well, it's unfortunate that there was miscommunication, or whatever the appropriate term might be, between the city, the commissioner's court, and the applicant on maybe not everyone having all the information they felt like they should have had. That's when the application came to us, we had a letter from the city saying it was appropriate for it to be in that area. And that's what we have to go off. I believe that's what the ED has to go off of.
yeah, and my view, I guess, is that to the extent that any of that created a notice issue, the notice issue has been cured. So I'm not concerned about that. And the state of play and the conversation about what the local zoning conclusions were, in my mind, certainly the post hoc stuff is out, but even the rest of it, I think, is something that we can set aside, because in my view, we have an independent duty to look at compatibility. And when I look at the map, you know, you put the bullseye on the waste processing building, and, you know, half of that circle is residential, including some homes that are quite close in.
In the mile
And,
radius, is that what you're referring to, that circle?
I
Or
think
the
we heard
500?
today 80 feet, certainly 150 feet, several within 500 feet, 100 within a quarter mile. And so that is what was compelling for me, just seeing this processing building really right up against the residential neighborhood.
Yeah, that's where that's really tough, because I do agree. I mean, there's no arguing. It's very close to residents, and I'm sure if you ask a lot of people there, then it seems like from the comments we received, they don't want it in their backyard, as the saying goes. However, it's hard for me to get to overturning because of the information in the registration, and I think it was probably a painful process to get there. I think the application should have been a little better when it came in the door, but they did end up meeting their burden of proof at the end of the day. And so it's hard for me to overturn it just on the fact that I feel like the applicant and the executive director more so met their burden of proof, as even though it was painful to get there. And that's a different discussion. That kind of goes into a notice of deficiency discussion, which I'm not going to get into here today, and that would be more appropriate in a different setting with stakeholders and everyone else. But at the end of the day, they did provide all that information, and when they submitted their application, they were, at that point, in an appropriate zoned area. And so I fall on that. I feel like for me, the burden of proof was met, even though it's tough. So.
Sounds to me like we're at a little bit of an impasse here.
I think so.
Trying to think how to advance
Procedurally, yeah.
advance the conversation
We can take a minute or two if you want.
here. Well, I think it might be useful, to the extent we're talking, to have that on the record.
That's fine. That's totally fine. It's tough. I think where you're coming from is the issue of it being the potential for something to not go right and residents to be affected because they're very close.
Right. And maybe I could ask you sort of about a few of those elements for me, what stood out. There was planning provided in the application around equipment failures and what happens in the event of equipment failures. So that feels to me like more than when you talk about potential, you're anywhere from, highly speculative or theoretical to this could happen on day one, and so where do we land? What does potential mean? There was planning, and I think it was, reasonable planning around equipment failure, but it just highlighted for me that, things can go wrong. There was an acknowledgement that there could be accidental spills of medical waste, and there were reasonable plans in the application to address that. But again, it highlighted for me that, things can go wrong. There was a conversation about the Kidd Street in front of the facility, helping to mitigate any odors that might be coming from the facility. The Kidd Street is farther away from the processing building than the residence is across the railroad tracks and the creek. And so, all that felt like, some form of kind of meaningful potential, not hypothetical. And these are, spills and equipment breakdowns and odors are things that could afflict even a well-operated facility. And I think what really got me is just the proximity of the residential neighborhood. Set aside how the local government views their zoning. I look at a piece of industrial property, but it is right up against the neighborhood. So that's just to add a little bit more granularity to how I arrived at where I arrived at.
Yeah, I respect that. I don't necessarily disagree with how you arrived there whatsoever. I just, I kind of come back to the basic, that's not basic, the burden of proof. And if the applicant met it, then I feel like we, they're owed the registration. One thing this isn't, they still have a number of, maybe not a number, they still have some issues to work out with the city. And I would hope that they would, if they were to receive this, that they would work with the city and address those issues so that the city feels more comfortable. I don't think those are appropriate for us to really talk about here today, but I do keep that kind of in the back of my mind. I just go back to, while I think it was a painful process to get here, and like I said, I don't think the application when it came in the door was what we wanted to see. We had to ask for more information, but they provided it. And at the time of when the application came in the door, the information that they provided, they met their burden of proof. And so
Do
that's
you
where I am.
see value in remanding to the executive director as opposed to denying the application?
What would you want to remand? Do you?
Well, I think what was lacking in my mind was a real evaluation about land use compatibility. I feel like what we received on the application, I think the application ultimately checked all the boxes. They provided everything that they needed to, but I think it was incumbent on our agency to do an evaluation of land use compatibility. And what I saw from the executive director, and I don't mean this as criticism, it was conclusory because the ED was relying on what the local government was telling them at the time about zoning.
If we were to remand it, Mary, maybe it's a question for you, but what would then be looked in? I mean, would any of the comments we received more recently be eligible to be considered, or how does that work?
Why don't I suggest that we take a recess and discuss that with
Okay.
the OGC attorneys?
Okay. Sorry.
No worries.
Stand by. You guys go first. How are you doing?
I'm good. I'm actually, I think, good. Thanks for that time. So I think where I would come down is I would be willing to remand this in order to obtain additional information on land use compatibility. But I want to be clear that this is in this specific case. You know, it was pointed out earlier that a lot of these sites, they are either in shopping centers. You know, they might not be, I don't know how close those might be to residential areas, but other ones that were up on a map earlier or not in residential areas. So maybe we do just need a little bit more information because this one is unique.
And I do view this as a very case-by-case
Very case by case.
analysis.
And so I would, you know, I'd be willing to remand it just to dive back into that
One
issue a little, just for clarification, because of the discussion we had on the buffer and on the easement and where, I guess, the description, I don't know if this is accurate to say, but where the machinery is within the site. So that way that's clarified and everyone kind of understands that better.
Not considering new information, but just looking at what was in the record.
That's my opinion.
Yeah, that
That's-
makes sense and works for me.
I don't know how to say.
Guess we needed to draft a
quick-
motion around that.
Yes. And remanding it just for a closer look at land use compatibility.
Now, I think we do have to overturn issuance of this registration in order to remand it. Is that correct?
Yes.
Okay. Do you want to wait for that motion and then do it all at once?
Yes.
Okay.
Yeah, makes sense.
Would you like to take
Let's take
quick
another,
recess?
let's take another little
That
break
motion?
to draft the motion. Yeah. All right. Commissioner Lindley, I've got a motion and just sort of a proposal how we lay this out. I think the two of us should sort of talk about and agree to the scope of the remand, and then I would offer a motion that we remand consistent with that conversation or with those agreements. And I think we've already initiated that. And I think part of those instructions would be, let's do it expeditiously. You know, the applicant and as well as the protestants have a lot invested in this exercise, and I don't want to add unnecessarily to that.
Agree.
So
Yes.
whatever expeditiously can be, let's do that. And in terms of the scope, I think we're looking solely at the question of land use compatibility.
Yes.
And in my mind, that would ignore anything that happened post hoc, certainly. And it would also be an independent evaluation, independent of whatever the local government had determined about zoning for this property.
I agree, yes.
Any other way you might want to qualify that? You were interested in the buffer issues?
I think that will mostly be addressed, but yes, I was interested in making sure it's clear in this registration that they are meeting the requirements and exactly how those are met. Maybe it's a good way to say it. That way it's clear. The 25-foot buffer zone is clear for everyone, and that there's, I think there's a little bit of confusion on the layout of the building, and so how all that's going to work inside the building. So kind of a technical, discussion of how the burden of proof was met for that, if it was.
And I think along those lines, while we're at it, let's try to get a good sense of how many residential properties are how close to this facility. It's a kind of an awkward way of saying it, but when I looked at for example, the 500-foot setback, I think I counted at least 17, maybe more than 20 properties above. The application and some of the conversation today indicated that there were 9, so let's try to get those sorts of things pinned down just for accuracy.
I agree, that's good.
Anything else?
I don't think so.
All right. I have a motion, which I'll read.
Okay.
Commissioner Lindley, I move that we overturn the executive director's issuance of registration 40294 to Medcare Environmental Solutions Incorporated, and to remand to the executive director for reevaluation of land use compatibility consistent with our conversation from the dais.
I agree. What do I do here?
I moved, so you get to
I second. Thank you.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. I want to thank Mr. Sorensen for being here today, Mr. Rodriguez, and the Perez's. Thank you, and thanks to staff for all of your work on this.
Yes, thank you all.
Next item.
Item number 2 is consideration of the ALJ's proposal for decision and order concerning the application by the City of Temple for vertical and lateral expansion of its Type 1 MSW landfill. The order of presentation should begin with the aligned applicant parties, the protestants, the ED, and then OPIC in that order. By letter dated April 5th, 2019, the Chief Clerk's Office provided 5 minutes of oral argument time for each party. The applicant may have some time for rebuttal as it bears the burden of proof on the application. And Mr. Moore for the aligned parties is here.
Good morning, Mr. Moore.
Good morning. Good morning, Chairman, Commissioner, General Counsel.
Mr. Moore, you got to check the light on that microphone, make sure we're turned on.
Is that better?
Yeah, and go ahead and repeat what you just said.
I said good morning. Good morning to you, Chairman. Good morning to you, Commissioner and General Counsel. I'm Brian Moore with the law firm of Beveridge and Diamond, and I am here this morning on behalf of the aligned applicant parties, as those parties have been come to be called in this matter. Those parties are the City of Temple, the owner of the Temple Recycling and Disposal Facility, and the applicant for the permit amendment that we're here today for. The other party is Waste Management of Texas, Inc., who's the operator of the Temple Recycling and Disposal Facility. We appreciate the thorough review of the application by the executive director and staff. And we also appreciate Judge Smith's equally thorough approach to presiding over the contested case hearing and her handling of the issues that were presented in the hearing. Of course, we support Judge Smith's proposal for decision and her recommendation that the permit amendment be issued. We offered only 6 housekeeping type exceptions to the proposal for decision, 4 of which Judge Smith has endorsed. Today, we would re-urge the other 2 exceptions that we made that Judge Smith didn't endorse, particularly our requested revision to proposed conclusion of law number 13, if the commission may be so inclined to adopt Judge Smith's proposed order in whole or in part. And with that, I will reserve the remainder of my time for rebuttal, but I'm happy to answer any questions that you may have for me now.
Thank you. Commissioner Lindley, any questions?
No, no questions. Thank you.
Thank you.
Thank you.
And I believe Mr. Morrison is up for the protestants. Morning, sir.
Morning, Mr. Chairman, Commissioner, Council. My name is Richard Morrison. I'm with the law firm of Smith, Murdaugh, Little and Bonham. I represent the protestants of the Flick family in this matter. I only have 5 minutes. I want to go over what I believe is our most important issue. This permit was, the executive director and the application had an unclear permit. Rule 330.57D requires the application to be complete, accurate, and clear. And regarding the location and size of the floodplains for the creeks that border the north of this landfill and the south of this landfill, both of the floodplains were unclear. The applicant's witness admitted that they were unclear and that they were bad maps. And the administrative law judge held that, well, they were probably just mislabeled, which nobody testified to. There's no evidence in the record that they were mislabeled, but again, the applicant admitted that they were unclear and bad maps. Now, the executive director's witness, the permit engineer for the TCEQ, said you could find the same information in the flood study. Well, if you read that flood study, it's 9 pages long. You can read it 100 times or 1 time. You're not going to find one word in there that describes the width and size of those floodplains. So again, I think the application was unclear, and because of that, there wasn't proper notice. And my clients asked for, in the very beginning of this suit, to have drainage added as a notice as part of the hearing, and were denied that. And we claim that that is as a result of the unclear application. And we think that it should be remanded for that. Again, here we are back to a narrow issue on remand, a narrow issue regarding the drainage of that landfill. And if we would have seen those size and location of the floodplains originally, we believe that there would have been a request for drainage in the beginning. And so we think that's our strongest issue, and we thank you for your time, and I can answer any questions.
Thank you, sir. Commissioner Lindley, any questions?
No, thank you.
No, thank you.
Thank you. Executive Director.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. I'm Shannon Love from the Environmental Law Division, and with me today is Steve O'Dill from the Waste Permits Division. The Executive Director respectfully recommends the Commission adopt the Administrative Law Judge's proposal for decision as revised by the Judge's letter dated January 31st. Thank you, and we're available for any questions.
I have none. Commissioner Lindley?
No, not this time.
OPIC.
Good morning, Commissioners.
Morning.
General Counsel and Executive Director. My name is Eli Martinez, and I'm with the Office of Public Interest Counsel for the record. We participated in the hearing and submitted briefs in this case, and we've reviewed the judge's PFD. OPIC concurs that the applicant met its burden to demonstrate that the application proposes sufficient provisions to prevent a nuisance condition under the MSW rules, including potential washout of MSW from the facility, resulting in pollution of the surrounding land. The Golder flood study credibly demonstrated that hydrological intrusions will not occur from Little Elm Creek Tributary Number 1 to the south of the facility, and the FEMA firm map did so with respect to possible intrusions by Williamson Creek to the northeast of the facility. Furthermore, the evidence demonstrated that no solid waste will be stored or processed within the 100-year floodplain. As to solid waste disposal operations taking place in a 100-year floodway, the evidence demonstrated that the 100-year floodway in this instance does not cross the permit boundary of the facility. OPIC therefore agrees that the applicant has met the burden of proof and supports adoption of the PFD. And thank you. We were available for any questions.
Thank you, Commissioner Lindley. Any questions?
No, sir.
Mr. Moore, I think you have about 3.5 minutes for rebuttal.
Thank you. Mr. Morrison, on behalf of the protestants, referred to their most important issue and their strongest issue. There's but one issue in this case. You referred over to SOA 7 issues. The protestants withdrew their challenge to 6 of those 7 issues on the day that they were to pre-file their testimony. We have one issue in this case. The issue that Mr. Morrison raised is not that issue. The sole issue remaining in this case was whether the application proposes sufficient provisions to prevent a nuisance in compliance with 30 TAC Section 330.15A2. Mr. Morrison's comments all concerned Section 330.57. That section is not at issue in this case. The only nuisance at issue in this case is whether the application would prevent a washout of solid waste from the facility. A washout, by definition, is the carrying away of solid waste by waters. Those waters, in this case, are flood waters. As conclusively demonstrated in the evidentiary record, in the application, and in the evidence that was put forth at the hearing, the entirety of the record, there are no solid waste disposal, storage, or processing facilities or operations located or proposed to be located within any 100-year floodplain. Accordingly, there can be no washout of solid waste from a 100-year flood. That is the only issue in this case, and that issue was conclusively answered by the evidence put forward in this case. Thank you for your time.
Thank you, Commissioner Lindley. Any other comments or questions at this point?
No, thank you.
Yeah, thank you, Mr. Moore. My read of the PFD is that the ALJ did a good job with this. I have no basis to overturn the conclusions of law or findings of fact. I think the evidence supports the permit amendment to expand this facility, and that's my view. How are you feeling?
I would agree.
Good.
So if you're ready, I can make a motion.
Sure, and I think in ordering provision 3, I think we should identify that the response to comments was the second revised version.
I'll include that.
And I actually thought that the exceptions that the ALJ addressed in the January 31 letter were appropriate, and so I think we should
include that.
Modify according to that letter.
Would you like me to make a motion, or do
Sure.
you want to?
Yeah.
Okay, I move that we adopt the ALJ's proposed order as modified by the ALJ's letter dated January 31st, 2019, but also add the phrase second revised before response to public comment in ordering provision number 3.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 3 is the consideration of the ALJ's proposal for decision and proposed order concerning the applications of James Trimble for a new on-site sewage facility site evaluator license and renewal of his on-site sewage facility installer and maintenance provider licenses. The order of presentation should begin with the ED, followed by the applicant and OPIC in that order. By letter of April 5th, 2019, the chief clerk notified the parties that each will have 5 minutes of oral argument time, and the ED may save some time for rebuttal as he bears the burden of proof on the denial of applications. So the executive director's staff is here to present the item.
Good morning. Good morning. Mr. Trimble, we'll have the executive director staff go first, and then it'll be your turn.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel, and Honorable Administrative Law Judge, which is not here. My name is Alicia Ramirez. With me is Ms. Haya Zeman, PE, Director of the Permitting and Registration Support Division. We represent the Executive Director in this matter. The ED agrees with the Administrative Law Judge's proposal for decision and proposed order and recommends that the Commission adopt them. We are available for any questions.
I have none. Commissioner Lindley?
No, not this time.
Mr. Trimble, it's your turn. Come on up, sir. Good morning.
Good morning. I just put on the form that I didn't really want to talk because I wanted to get counsel. Am I allowed to get counsel?
You are allowed to be represented by counsel, yes, sir. I don't know what that means for where we are procedurally at this point, what sort of deadlines might trigger, and I don't know if we have time to do that, but let me have a little sidebar with my lawyer and see what we can do. Mr. Trimble, I just want to make clear that the state does not have counsel that it can provide for you, but if you want to hire your own lawyers, we could give you time to do that and come back and represent yourself through a lawyer if you like.
Yes, sir.
Okay. Commissioner Lindley, I'd move that we continue this matter until the May 22nd agenda.
That's fine.
So I so move, if you'll second.
I will second.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries. We'll see you May 22nd, sir.
Yes, sir.
Thank you. Next item.
Item number 4 is an application by Blue Sky Farms LLC for a major amendment to TPDES permit number WQ 00030777000 to authorize the modification on an existing dairy cattle concentrated animal feeding operation by expanding the land application area. The parties have been notified that the commissioners will not take oral argument but may ask questions. And we have several parties signed in, and their presence will be noted for the record.
All right, Commissioner Lindley, Mr. Cannon and Cannon JWC Ranch have requested a hearing in this matter, citing relevant material issues. The ranch property is contiguous with and down gradient of the applicant's property. I think it's pretty clear that we have an affected party, and I would propose that we refer this matter on the issues that he presents, as well as referring this to our ADR program.
I agree on that, and I can make a motion if you'd like.
Great.
I move that we grant the hearing request of Ernest Cannon and Cannon JWC Ranch LP, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrent with SOA's preliminary hearing scheduling efforts, that we refer the application to SOA for a contested case hearing on the following issues. A, whether the draft permit contains sufficient provisions to protect the health of the requester's livestock, and the requester's use and enjoyment of their property. B, whether the permit complies with applicable buffer zone requirements and regulations. C, whether the draft permit complies with applicable nutrient management plan and/or nutrient utilization plan requirements and regulations. D, whether the applicant's compliance history prevents issuance of the draft permit or requires specific permit terms in the draft permit. E, whether the draft permit is protective against the discharge of manure, sludge, or wastewater from a land management unit. F, whether the draft permit contains sufficient provisions to prevent nuisance odors. And G, whether the draft permit complies with applicable monitoring, management, documentation, recorder keeping, and reporting requirements. And that we set the duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
Item number 5 is the application by K&K Construction Incorporated for air quality permit number 141957. The parties have been notified that the commissioners will not take oral argument but may ask question. The parties that have been signed in, their presence will be noted for the record.
Commissioner Lindley, on this one, we have 2 requesters, and Mr. Bistroff has failed to identify any issues, and so we're unable to grant his request. Mr. Buckholtz has identified several material and relevant issues. And in addition to that, his property is within a half a mile of the facility, so he may be affected in a manner that's different from the general public. So I would grant his request, and if you agree, I'll try to summarize the issues.
I do agree.
I see the following issues: whether emissions, including dust, will adversely affect air quality or the health of the requester and his family, whether the applicant's compliance history warrants additional permit provisions or denial of the permit, and whether the residence is located within 440 yards of the facility. How's that sound?
That sounds good.
Okay.
I agree.
And I'd also propose an ADR referral, and also think that it's appropriate to deny the request for reconsideration here, and I'll take your recommendations on a hearing duration.
I agree in all that, and I think because there's just one party or one protestant, and the issues are fairly limited, a shorter hearing.
I'm good with that.
Seems fine, and
Sure.
so I would propose 120 days as
Sure.
opposed to 180. If you'd like me to make a motion, or if you would like to.
I'll entertain a motion. Thank you.
Okay. I move that we grant the hearing request of John Buckholtz, I apologize for that. Deny the remaining hearing requests and all requests for consideration. Refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrent with the SOA preliminary hearing scheduling efforts. That we refer the application to SOA for a contested case hearing on the following issues: whether dust whether dust and emissions from the facility will adversely impact the health of the requester, the requester's family, whether the applicant's compliance history warrants additional terms or conditions in the draft permit or denial of the draft permit, and whether a residence is located within 440 yards of the facility. Were those all the issues that you wanted, or was there something else?
Keep going. Let's
Okay.
see if you pick it up.
Whether dust and emissions from the facility will adversely impact air quality. Lastly, that we set a hearing duration of 120 days from the date of the preliminary hearing until a proposal for a decision is issued.
I'm sorry, I'm not sure I heard you correctly. I'm going to make you reread that, or I'll read it.
Well, you read yours, because I think I know what you want, and I think I might have,
Okay.
yeah, I'd rather go with yours. I'll say that.
All right. Commissioner Lindley, I move that we grant the hearing request of John Buckholtz, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrent with the SOA preliminary hearing schedule, that we refer the application to SOA for a contested case hearing on the following issues. Whether the residence is located within 440 yards of the facility, whether the applicant's compliance history warrants additional terms or conditions in the draft permit or denial of the permit, whether dust and emissions from the facility will adversely impact the health of the requester and the requester's family, and whether the dust and emissions from the facility will adversely affect air quality. I further move that we deny the remaining hearing requests and all requests for reconsideration, and that we set a hearing duration of 120 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 6 is the application by United Front LLC for new TPDES permit number WQ00155630001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those parties that have signed in, their presence will be noted for the record.
Commissioner Lindley, on this one, we have a no increase renewal, so there's no right to a hearing in this case unless the applicant's compliance history raises issues about the applicant's ability to comply with the permit. I'm on the wrong item.
Yes.
Scratch that.
I was getting nervous.
We'll get to that. We'll get to that one.
I've done it.
This is what
You're in
happens
good
when I have
company.
to work more than an hour and a half straight. I just wear myself out. All right. We're on item 6. This is the request for a hearing on, multiple requests for hearing on the United Front TIPDES application, and there are 5 requesters on this item. My apologies. Ms. Medvey, Ms. Ward, and Mr. Wick have not, in my view, identified a personal justiciable interest, since their properties are a considerable distance from the proposed discharge. Ms. Landers and Mr. Young, however, own property that's adjacent to and downstream of the proposed discharge, and they've raised relevant material issues. So I believe Ms. Landers and Mr. Young are entitled to a contested case hearing. And if you agree with that, I'll review the issues.
I do agree.
I think in terms of issues, we're looking at impacts to surface and groundwater, the characterization of the receiving streams, impacts on cattle and wildlife, and the accuracy of the application.
I agree.
Okay. Did you catch all that?
I believe so.
Okay. And, you know, again, I'd suggest that we refer this for alternative dispute resolution.
I would agree, and I'm comfortable with 180 days on this one.
Sounds good.
Okay, I move that we grant the hearing request of Rhonda Landers and Bradley Young, that we deny all remaining hearing requests, that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrent with SOA preliminary hearing scheduling efforts, that we refer the matter to the State Office of Administrative Hearings for a contested case hearing on the following issues: whether the proposed discharge will negatively impact surface or groundwater, whether the application has accurately characterized the receiving streams, whether the treated effluent will negatively impact the cattle and wildlife in the area, and whether information provided in the application is accurate, and that we set the duration of 180 days from the date of the preliminary hearing until the proposal for a decision is issued.
The motion has been made. I second it. All those in favor say aye.
Aye.
Aye. The motion carries.
Item number 7 is the application by DHJB Development LLC for renewal of TPDES permit number WQ0014975001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those parties that are here, their presence will be noted for the record.
All right, Commissioner, I think I'm back on track.
Yes.
This is the no increase
Yes.
renewal. There's no right to a hearing unless we have concerns about the applicant's ability to comply with the permit based on compliance history. And the compliance history classifications are satisfactory or better, so that does not raise an issue. I note that there were a couple of violations that were not calculated into the compliance history score. In my evaluation, neither of those implicate an inability to comply with the permit. And so I think it's appropriate in this case to deny the hearing requests and to grant the renewal.
I would agree, and one thing that I also wanted to note that, this, I know there are people that have concerns with, this permit application. However, there are things in the current application up here, or before us today, that are more stringent, I think, than normal, and so I just want to note that. And
that's a good point. This
Yeah.
is more than a no increase renewal. We're actually making the permit more stringent.
Yes.
Yeah.
So
Thanks for pointing that out.
I would agree that the hearing requests should be denied, and I can make a motion if you're ready.
Great.
I move that we find that no right to a hearing exists on the application, that we deny the hearing request and request for reconsideration, that we grant the renewal of the TPDES permit number WQ0014975001 to DHJB Development LLC as recommended by the Executive Director, and adopt the Executive Director's response to comments, but correctly note on page 2 that the Commission granted the hearing request by Patricia Graham and referred the 2012 application to SOA for a contested case on 4 issues, where the ALJ admitted Terrell Graham, Margie Hastings, Asa Dunn, and the Greater Edwards Aquifer Alliance as parties aligned with Patricia Graham as protestants at the preliminary hearing.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
That takes us to our enforcement docket, items 8 through 58. The executive director's staff will be here momentarily to present these matters. On items 12 and 58, we have several individuals who have signed in but indicated that they don't wish to speak unless the commission has questions, and their presence will be noted for the record.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for the Litigation Division. With me today are Charmaine Backens, also of the Litigation Division, and Melissa Cordell and Michael Dela Cruz of the Enforcement Division, representing the Executive Director. Pending before you are items 8 through 58. The total assessed administrative penalties are $628,150, with $121,638 deferred, $213,065 applied towards supplemental environmental projects, and $293,447 to the general revenue. The Executive Director respectfully requests approval of these items, and we are available to answer any questions you may have.
I have none. Commissioner Lindley?
I also have none.
Mr. McWhirter?
My office reviewed these items, and we recommend approval of the orders.
I agree. I've reviewed these items and think it's appropriate to move forward with
I agree.
approval.
I move that we adopt items 8 through 58 as recommended today by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
That takes us to item 59, which is consideration of the monthly enforcement report. The Executive Director's staff is here to present this item.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Michael De La Cruz of the Enforcement Division and Charmaine Backens and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2019 through February. There were 629 effective administrative orders issued, and of those, 77 contained supplemental environmental projects. These orders assessed a total of $6,070,856 in penalties, with a payable amount of $3,745,592. $1,375,153 are to be paid towards supplemental environmental projects. 8,311 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 787 enforcement action referrals have been received. There are 1,560 pending administrative orders, with 129 cases that are on the backlog. 217 cases are pending at the Attorney General's office for representation in district court, and 9 judgments have been issued. 2,102 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2017, 18, and 19. We are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley?
I don't have any either.
Mr. McWhorter?
I don't have any questions, thanks.
Appreciate the report. Thank you.
That takes us to item 60, which is consideration of the adoption of the El Paso redesignation request and maintenance plan, state implementation plan revision for the 1-hour ozone national ambient air quality standard. The Executive Director's staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. I am Margaret Ernest with the Air Quality Division, and with me is Terry Salem with the Environmental Law Division. Additional staff are also available to answer questions as needed. For your consideration today is the El Paso area redesignation request and maintenance plan SIP revision for the 1-hour ozone national ambient air quality standard, or NAAQS. The SIP revision includes a request that the EPA redesignate the El Paso area to attainment for the 1-hour ozone standard and provides a maintenance plan that will ensure the area remains in attainment of the NAAQS through 2032. The SIP revision would also include a request that the EPA consider this plan as a second 10-year maintenance plan for the 1-hour ozone standard. Public comments received during the comment period have been summarized and addressed in the SIP revision. Staff respectfully request adoption of this SIP revision, and we're available to answer any questions. Thank you for your consideration.
Thank you. I have no questions. Commissioner Lindley?
I don't have any questions either. Thank you.
Mr. McWhorter?
OPIC recommends adoption of the El Paso redesignation request and maintenance plan state implementation plan revision for the 1-hour ozone national ambient air quality standard as presented by the Executive Director.
Thank you. Any questions or comments?
No, I agree that we should adopt.
I think we're well practiced on these
Yes.
issues by now, and I'll entertain a motion.
I move that we adopt the El Paso redesignation request and maintenance plan, state implementation plan revision for the 1-hour ozone national ambient air quality standard as recommended by the Executive Director.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries.
That takes us to items 61 through 66, the quadrennial rule reviews for chapters 15, 19, 21, 25, 30, and 86 of the Texas Administrative Code, Title 30. And the Executive Director's staff is here to present these matters.
Good morning.
Good morning. Good morning, Chairman Neerman, Commissioner Lindley, General Counsel, and Public Interest Counsel. For the record, my name is Patricia Duran with the General Law Division, and with me today is Todd Gallagher, Senior Attorney from the Environmental Law Division, representing the Executive Director. Pending before you are items 61 through 66, the adopted rule reviews of 30 TAC chapters 15, 19, 21, 25, 30, and 86. As required by Texas Government Code Section 2001.039, Executive Director's staff conducted rule reviews of these chapters to determine if the need for the rules within the chapters continue to exist. The proposed notices of the rule reviews of chapters 19, 25, and 30 were published on October 26, 2018, issue of the Texas Register, comment period from October 26, 2018 through November 28, 2018. The proposed notices of the rule reviews for chapters 15, 21, and 86 were published in November 9, 2018, issue of the Texas Register, comment period from November 9th through December 12, 2018. No comments were received during the public comment period for these reviews. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules continue to exist. We respectfully recommend approval of the adoption of the rule reviews of 30 TAC chapters 15, 19, 21, 25, 30, and 86. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. Project managers and attorneys assigned to each of the chapters are here with us to answer any questions.
Thank you. I have none.
I
Commissioner
don't have any
Lindley?
questions either. Thank you.
Mr. McWhorter?
OPIC recommends adoption of these reviews and readoption of these chapters as recommended by the Executive Director.
I agree, and
I agree.
will entertain a motion.
I move that we adopt the rule reviews and readopt the rules in Chapter 15, 19, 21, 25, 30, and 86 of Title 30 Texas Administrative Code without amendment.
The motion has been made. I second it. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 67 is the public comment session. We do not have anyone currently signed in to speak at this time. So that takes us to the end of the items posted for open session. Items 68 through 71 are for closed session, but the commission will not meet in closed session today.
The time is 11:40. We're adjourned.